case of the morning, David Weinhoffer versus Davie Shoring. Appellant's counsel can come forward as soon as you're ready. Please.
Good morning, Your Honor. Josh.
Take your mask off, please.
Good morning, Your Honors. Josh Cook for the appellant, David Weinhoffer as liquidating trustee for offshore specialty fabricators. Judge, we're here today in connection with an appeal from what the appellant contends was an abuse of discretion by the district court in connection with the admissibility, with the admission of certain exhibits. On April 23, 2018, the bankruptcy court for the Southern District of Texas entered a revised order authorizing David Weinhoffer as a liquidating trustee to engage Henderson Auctions to advertise and sell a large accommodation module that had previously been salvaged by OSF and placed on property adjacent to its property, on a piece of property owned by Offshore Express.
So the case doesn't turn on this, but just to be sure, does this house 205 people? Is that the idea?
Yes, sir. Huge piece of it.
Seen a blurry picture of it, but I wasn't sure what to expect. Go ahead.
The order provided for Henderson to obtain the highest possible price they could for the module. Henderson, pursuant to its, entered into a contract with Weinhoffer. The auction agreement in connection with the advertising, Henderson Auction advertised the auction beginning sometime, I believe, in early May, late April. The auction advertisement is, I've actually presented a copy to Your Honors. It's Exhibit 6. You'll see that the advertisement itself identifies on page 2, this is ROA 1664, the actual auction terms. These include 10% buyer's premium, loadout can be moved by barge, loadout must be scheduled, discusses the terms of payment, full settlement is due on the day of the auction, and general auction site policies.
Let me ask, hold on just a second. Has this been provided in some way, Kim, to Judge Higginbotham? Okay. I mean, it's provided to us this morning. Okay.
There are actually 2 copies here. These were taken from, these were screenshots that were actually taken from an archive, website archive. And you'll see that the first one is dated May 3, and then the second one is dated May 17, the day after the May 16 auction. If you go to the, I guess it's the third page, you'll see where there is a reference to the site being hosted by a company called Auction Time. And I'll call this to your attention because there is a issue as to, you'll hear further about the Exhibit 41, which is specifically at issue here, which was admitted into evidence by the judge, by the district court over our objection. And that was actually came from Proxy Bid, a competitor and a totally different auction platform. The
competitor to whom?
I'm sorry, Judge?
A competitor of who?
Of Auction Time. Auction Time and Proxy Bid are 2 different auction platforms.
Okay, is there an issue of the case of where the Proxy Bid was entitled to be posting this and entitled to be setting terms?
Well, this is part of the reason that the whole issue of trustworthiness and the introduction of these documents is so important. perhaps if I went on a little bit further, I think it would put it into context, Judge.
Well, I've read the briefs and they had that context. Proceed, if you can elaborate further.
Maybe I don't understand.
No, but it tells more. But it seems to me that what the briefing is indicating is that Henderson auction, including testimony that was provided, affidavit or testimony, is that there was nothing improper about proxy bids posting this information and taking bids through that, even though that's not where the winning bid was presented. That was done by telephone.
Judge, we don't even know if Proxy Bid was the auction site hosting this particular bid. What we know is that...
What do you mean, this particular bid? This particular auction?
The successful bid by Mr. Davie.
Okay, the actual bid itself, the single bid.
Mr. Davie's bid on the module at the auction, an online auction on May 16th of 2018, and was a successful bidder. He bought it for $177,500. Mr. Davies claims that he saw these special terms, because if you look at Exhibit 6, there's no reference to this 20% liquidated damage provision, which the district court found to be applicable in this case, substantially reducing the award of $177,500 down to 20% of that amount.
Where is the information on Exhibit 6 found online? Not today. Where would it have been found online in 2018?
It pulled off the Wayback Machine, Your Honor.
No. Where would it have been found online in 2018?
It would have been found on Henderson Auction's website.
So that is the Henderson page.
Yes, sir.
Exhibit 6.
That's correct, Your Honor.
All right.
So Henderson puts on its website an advertisement for this module, sets forth what the terms are. There's claimed to be a button that a person on the website could press, and the button read to enter the to register or to obtain additional pictures, press this button. Now, all of these websites that are archived, so for instance, the archived on the by the Wayback Machine.
What were the terms? What do you believe the terms were? Is there
terms are as appear clearly on Exhibit 6, Your Honor.
But I get a link on here. Didn't we just establish that there was a link?
Here's the problem with the link. First, the Wayback Machine doesn't enable you to go, doesn't save the...
Well, I'm not talking about the Wayback Machine. Again, I'm
Yes, sir.
following up on Judge Southwick's question about at the time that this bid was opened, your client prepared what would be online as Exhibit 6, correct?
Henderson Auction prepared.
Henderson. Okay, Henderson prepared at your direction or at your client's instance,
Yes.
want to have an auction, piece of property, and prepared what is Exhibit 6, which has a link at the top. I guess it's at the top of page 2. You mentioned page 3. Well, I see Henderson Auction on here. What were the terms that were offered at the time? Before we get into the evidence, and I know there's some authenticity questions, and you raised some good issues about that, what were the terms when this bid was placed?
Well, and that...
With regard, and I'll be more specific, with regard to if you fail to pay the amount, were there 20%? Was that
These were the
penalty?
terms, as far as we were aware, as far as Mr. Weinhoffer was concerned as the trustee, these were the terms. As far as Mr. McCann was the representative of Henderson Auction that Mr. Weinhoffer dealt with and that Mr. Davie dealt with, because Mr. Davie did not register for the auction. Now, if you press that button and enter the proxy bid platform, according to Mr. McCann, the only way that you can see those terms and conditions, these special terms and conditions that Mr. Davie claims were there, is to register for the auction. And Mr. Davie did not register for the auction. Therefore, there is no way that he could have seen these terms and conditions.
But if he doesn't see the terms, do they not exist? I mean, you know, if
he doesn't agree to them, he can't, it's an oral agreement because he's never registered. He's never signed anything agreeing to any of the terms that are set forth in the contract. We don't know whether the proxy bid special terms were even a part of this contract, of this agreement, of this auction. And the reason for that is that it's impossible to tell because we can't pull up a live copy of the website, the Henderson website, and press a button and see what it takes us to. Can't do it, and haven't been able to do it. In fact, the first time that we understood, we discovered or were told that these special terms with the liquidated damage provision were after we had filed suit, and Mr. White, counsel for the appellee, claims that he went back on the Wayback Machine and he found this proxy bid special terms, and that including the liquidated damage provision. There is nobody at Henderson that has ever testified as to what those terms were. There's not a witness from Henderson. The only witness that has ever testified to having read this alleged liquidated damage provision was Mr. Davie. At trial, Mr. Davie was asked about having read this. Mr. Davie couldn't remember where he had read it. He thought maybe it was in a handout rather than online. And then when we took Mr. McConn's testimony, Mr. McConn confirmed that there's no way he could have seen it because he was not registered. Now, so we don't have a single witness, and there is not any testimony in the record about whether or not this liquidated damage provision was in this website. Now, what happened was that Mr. Davies is the high bidder. He goes the day after, he puts a lock on the module, and has testified that he considered that he owned it. So it really wasn't even essentially a default. I mean, at that point, he considered that he was the owner. Mr. McConn, who had been dealing with Mr. Davie over the years, sent Mr. Davie an invoice for the $177,500 plus the 10% commission, plus he was under an obligation to remove it within 60 days. Mr. Davie did nothing. Mr. Davie continued to ignore subsequent requests for payment and subsequent requests to move it, and went totally silent. Totally ignored Mr. McConn, ignored Mr. Weinhoffer. By December, the plan of liquidation was going to be effective at the end of the year. So when they got around to December, this big module was sitting on a piece of property owned by Offshore Express, a related company, but entirely different company.
So we're getting a little past the evidentiary issue that you brought to the court. What relief would you expect, if assuming we would agree with you with regard to the admissibility?
I would suggest that there is no evidentiary basis to support a finding that this liquidated damage provision applied.
What about his own testimony, if it's found credible, and you've mentioned all the reasons why it shouldn't?
It's impossible for him to have seen those terms and conditions, Your Honor.
So it was not credible, and any fact finding by the district judge to a different effect should be overturned?
It would overturn the district court's decision to apply the 20% liquidated damage.
Well, I'm just saying, but it's a fact finding, and that the district court, you're saying it would be impossible for Mr. Davie to have been aware of this at the time of the bid. And the district court found to the contrary, did he not? Or she, was this Judge Vitter?
The district court, I believe, found that Mr. Davie had read it, but then she went off to rely on the introduction of the proxy bid terms from the representative of Henderson. The problem with that... Okay, we can sort that out. You really have limited time, and we haven't gotten... And I don't think we'll be able to get to the key issue. Let me ask you a few things that you're raising that I don't understand that you were raising from the briefing. Are you arguing that proxy bid had no authority to be setting these terms, no authority even to be taking bids on this? Well, what was proxy bids in your position in this case now? Not saying there was anything different earlier. What is your position that proxy bids' legitimate role as to this auction was? We don't know. I think that proxy bid was not involved in the first auction, truthfully. I think proxy bid was involved in the second auction because in December, OSF ended up transferring this module to Offshore Express so they could get out from under the liability of having to move it and the potential pollution exposure, et cetera, et cetera. So they transferred it to Offshore Express. Now, Offshore Express then auctioned it using proxy bid. And if you look at the second exhibit that I've given to your honors, Exhibit 41, which is a screenshot from the website which was introduced during the course of the trial, and which is the exhibit which the district court relied on, at least in part, to conclude that this liquidated damage provision was there. If you look at that, I have highlighted the date, which is a reference on page 2 to
So let me ask you a factual question.
February.
I'm having difficulty understanding how your client learned that this nodule was available, et cetera, and did it by phone without any terms and conditions. And how would that be accepted when it was apparently also being, as you say, auctioned by a engaged auction firm?
I'm sorry, Judge.
In other words,
I'm very sorry. I'm having a hard time understanding what you're saying.
What I'm saying is that you, as I understand what you've been arguing, that your client just picked up the phone and called and put in a bid, and what does the record show he was talking to? Critically, my question is that you have an engaged auction firm, as I understand the record, and someone bypasses the entire system, doesn't register the auction itself, and calls. What does the record show that your client, who did they talk to and et cetera? Accepted a bid. Who were they? What were they accepting? Is a stranger to the bid process?
What were they?
Who was called and the $177,000 bid placed with that person? Who was that? Somebody with proxy bid? Somebody with Henderson?
That was Mr. Davie was on a telephone
With whom?
with McCann at Henderson Auction. And McCann was entering whatever the information was.
Was that, in your view, a legitimate way to bid? And if so, how do we know that was a legitimate way to bid? Certainly the way it's been presented here, the argument has been, and I think was accepted by Judge Vitter, that it was proper to bid through proxy bid. And that's not what happened insofar as the winning bid was concerned. So how much of that are you contesting, of what was proper and how to bid on this property?
Yes, I'm not contesting the bid itself. I'm not contesting the $177,500 bid and that it was accepted and that it was the high bid. That's not an issue. The issue is the trustworthiness of these records. I mean, there's not a single witness that can testify that did testify that these were that this liquidated damage provision was a term of the auction. And we do know from looking at Exhibit 6 that it was not in there. And then we look at Exhibit 41, which makes reference on page 2 that all items must be removed by February, which would be consistent with the second auction by Henderson. But there is not a single witness we can cross-examine on any of this. We can't, no witness was produced from proxy bid.
All right, counsel, we have your argument. Thank you.
Thank you, Judge.
Good morning, Your Honor. My name's James White. I represent Appalachia Davie Shoring. I think there's some things that need to be corrected.
Well, at least clarified. Why don't you help us out here?
First of all, proxy bid, there's no evidence in here. In fact, to the contrary, Henderson embraced and claimed the terms and conditions of the auction as its own. They're saying we were responsible for placing those via embedded links. So proxy bid was the bidding platform.
The bidding platform?
It was a bidding platform.
Because I heard earlier about a competitor Were there other bidding platforms that would have been appropriate to use, and how would anybody have accessed them?
It's possible, Your Honor, that there were, but there's no evidence in the record regarding that. What Henderson focused on in its testimony and what it produced in response to our subpoena ducis tecum, which specifically sought all documents electronically stored and otherwise that related to the terms and conditions of the auction, and this is what was produced. And it was a proxy bid document. So this is what was produced. Mr. McCann...
What is Exhibit 6 in your...
Exhibit 6 is an outdated copy. We addressed this in Record Document 76, and I'll see if I can find an appellate site for that.
We can find it.
But what we did, and that was in connection with the court's ability to take judicial notice and our request that it do so, what the appellant put up was a copy of a May 3rd version of the website. We had the May 11th version, which was the last published version prior to the auction. And it had more information on there, including a click-through link, which linked, and as confirmed by the Henderson witnesses, that had an embedded link in it, which directed you to the proxy bid web platform. And Henderson had put its terms and conditions, its photos, its descriptors in that document that it sent to proxy bid for publication on that website. And I think there's an issue here as to whether this document production was something within Henderson's custody and control.
Well, before we get to that, though, isn't the first issue whether or not the witness, was it Ms. Martin?
Ms. Martin, yes.
Whether she or anyone else who testified at trial could authenticate the proxy bid documents that you're referring to. Isn't that the first bridge we have to cross, is authenticity?
Yes, Your Honor, and that, as you know, that bar is low when it comes to a document production. And again, the objection is, hey, this was not Henderson's document. Yes, it was. It was Henderson's document. Henderson put it on the proxy bid website.
But to be clear, it was a document that was subsequently recovered. It was one like the Henderson. In other words, if I click I think that what makes this a little more confusing is that we go to the website to bid, and that's a Henderson organized website, and it has a link on it which incorporates yet another website which has terms and conditions. So the Henderson witness, who is Ms. Martin, she can authenticate the Henderson documents, and so the issue is really, can she also authenticate documents, or a website in this case, we use the term documents, something that is linked into, bootstrapped into the Henderson website. Is that a fair characterization?
I wouldn't call it bootstrapping, Your Honor. I don't see this as being any different than saying, I don't have this document in my office anymore, okay? I put it off-site storage, okay? Somebody else has it.
Somebody else's storage.
But it's still my document. It's within my, and if we go back to Rule 34 for document production, you know, the courts have ordered parties subject to a request for production or to a subpoena to produce documents within their custody, control, and possession, whether it's a legal right or whether it's the practical ability to recover that. And that is exactly what Henderson did. It had probably the legal right, since it has a contract with Proxy Bid for Proxy Bid to be its bidding platform, yet it was still very easy for Ms. Martin, once she was instructed, say, we don't have this, this is where you go find it, for her to retrieve that document. So they're not disclaiming the document at all. Henderson is telling us that what we put on that auction website and what we link to Proxy Bid is what we produce to you.
Let me ask you, I understand that you're maintaining its authenticity through Ms. Martin's testimony. For the sake of argument, if if she is not able to authenticate the document, and we agree with your opponent, is there any other way that it can be admitted into evidence on this record?
I think that, again, the court could take judicial notice of what was published at the time. There was an active proxy bid website. Again, if we hearken back to our document 76, which is our reply on the judicial notice issue, there was still a live link to the proxy bid website. It wasn't an archived link, it was a live one, and you could click on that and get the same auction terms and conditions. And for the first time today, I'm hearing, speculation that maybe these auction terms applied to a later auction. That argument was never raised at the trial court, but it's undermined by the document itself, which clearly shows the auction date of May 16th, and that's what was at issue.
I don't want to, you may still be answering Engelhardt's question, but let me ask, what about the reference that your friend on the other side made that there's a property must be removed by February? Isn't that a change from what the original auction would have provided?
Your Honor, we've looked at this, and it has the same FEB XXX in all versions that we know of. So it was just a typo, but or whatever. But that's what was published.
Is there any question in this case of whether proxy bid was properly authorized by Henderson to set terms like this 20%?
Your Honor, those were Henderson's terms and conditions, not proxy bids. If you look at that document, it talks about...
Well, regardless, thank you. The answer to my question is no, that there is no question in this case that what was on proxy bid's website of 20% would have been authorized to be presented there by Henderson.
To get to that conclusion, you have to sort of reject Henderson's own testimony about how they authored and prepared the terms and conditions of the auction, and they said they did it. So they're not saying that proxy bid did it and that proxy bid was not authorized to publish these, because Henderson claimed authorship of the terms and conditions. They said, these are our terms.
Remind me of the testimony. Does Henderson acknowledge that they were limiting damages to 20%? Or just acknowledging, yes, that's what it says, without necessarily recalling that was the limitation?
That's more the case, Your Honor, because they're saying this is the document and it is what it is.
Is it clear from the evidence who prepared that? I mean, it appears on proxy bid's website, correct?
Yes.
Exhibit 41.
And through Henderson, yes.
Well, right. Is there any question about who actually prepared that? Who actually typed it up? Who actually did whatever you have to do to massage it and ultimately get it on proxy bid's website? Was that part of what was explored?
Ms. Martin referred to a lady by the name of Ms. Casson, I think Jennifer Casson, who is the marketing manager, and she was responsible for the terms and conditions of the auction.
Is that a standard term and condition for Henderson? I take it it's not.
Mr. Davie testified he had seen similar terms and conditions.
But nothing from Henderson about whether that was a standard term that they have in their auctions.
Mr. Davie testified that he had bid through Henderson before, and he had seen similar terms. He said these look like they're standard terms and conditions.
Davie sort of has his own interest here, and I just want to see, did Henderson ever confirm that? Did anybody from Henderson ever say these are standard terms of an auction?
No, Your Honor. Again, all they did was claim ownership and authorship of the document.
Is there any other support in the record other than Mr. Davie's testimony and this exhibit at issue here, the Exhibit 41? Is there any other evidence? By that I mean testimony or documents. It sounds like this is the only document, which is why we're arguing about it today. Is there any other evidence in the record that would support the 20% damage figure?
Well, I think that other than Mr. Davie's testimony, I think what you have to do, again, Your Honor, is look at the entire body of the advertisement. A big issue at trial and on which the plaintiff prevailed was that Mr. Davie was not excused from taking delivery of this. Now, Mr. Davie had good reasons because it was a 3,000-ton unit. The steel structure on which it was resting was defective or dangerous, and nobody would move it. Judge Vitter said you should have asked somebody before you bid, and that was the basis for her judgment. But Davie's defenses in that case, which Judge Vitter rejected, was, please let me disassemble it, and I can't move it in 60 days, I need more time. The 60-day provision is found nowhere in any document other than what is Exhibit 41 and what is published on the Wayback Machine. So they were trying to enforce that. That was subject to a lot of testimony. I'd like more time. His consultant said, you're going to need months to move this. And ultimately, he failed to take or refused to take delivery because he just couldn't do it. So, and the subsequent owner, which was the affiliate of OSF, did allow for it to be disassembled on site and scrapped. Mr. Davie would have been happy to have done that, but was not permitted. So he was bound. And again, going back to the arguments that it was impossible for Mr. Davie to know these terms and conditions, that's just not correct because the links are actively clicked on. Ms. Martin testified to the same thing. Mr. McCann of Henderson also testified. You click on the links. There were the May 6th version of this had links in it. It just wasn't highlighted properly. So the terms and conditions were known, but assuming that Mr. Davie never read them, isn't he bound by them anyway? You can't, there's no law I know that says I'm not bound by something because I didn't read it.
Well, but he didn't bid in the way that the link would have provided. Part of what was argued here in the briefing is that this was a phone call that bypassed access to proxy bids insofar as the bid itself was concerned, proxy bids website where the terms would have appeared. He calls somebody at Henderson Auction, correct?
Yes, the sales manager who
places the bid. It does seem to me that if all you see on Henderson's side is what's there, Exhibit 6, and maybe you said that's out of date, but you don't see this term, and Henderson accepts a phone call from a bidder without assuring an understanding of the terms, where is the meeting of the mind on this particular point?
Well, if we go down that road, there's no meeting on the mind on a 60-day requirement to move or a prohibition against disassembly of the unit. So you're opening up an entirely larger can of worms here. Mr. Davie admitted he read that, and he could have only have found those out on site by visiting the website.
We have been urged in the previous argument to overturn that fact finding. Let's say we do, that there's no evidence that convinces us that the judge probably made that fact finding. So let's say he didn't see those terms. Is he bound by them anyway, even though Henderson Auction didn't require him to go to the website?
Well, I asked Mr. McCann that question on his direct or cross-examination.
That's Henderson's whatever salesman?
He said everybody was treated the same. All bidders were treated the same, including Mr. Davie. So and Mr. McCann did Mr. Davie a favor by saying, I'll put, you phone your bids in, and I'll put them in for you through the proxy bid platform or otherwise, and Mr. Davie followed the auction along on his computer. So he was online. Mr. McCann's testimony...
Follow along online other than through proxy bid's website?
Now, he was able to follow along through the proxy bid, yes, and see what the bids were, and then he would phone in and say, Jeff, I'd like to up the bid by X number.
He had to be on proxy bid to do that, or could he do that from Henderson's website?
He did that by dialing through by phone directly to Mr. McCon, and Mr. McCon used his login account to do it.
What is he looking at in order to phone in again and say, I want to bid? I don't know what the bidding process was, but I seem to understand, you seem to be suggesting that he placed a bid, he goes online, he looks and sees, oh, I want to up my bid.
Yes.
Because someone else has bid. So he calls again and says, I want you to, and then there's somebody there, the gentleman you identified, who enters his new bid. Is that an accurate description?
Yes, Your Honor, it
Okay.
is.
So
And
you're
again,
saying
that
he had
wasn't-
to look at the website in order to know what bids were incoming?
Right.
Okay.
Right, because it was the platform, you could almost liken it to eBay. You know, so you have individual merchants, but they put their items on eBay. eBay's the bidding platform, but, you know, you actually end up paying the merchant. The merchant has its own terms and conditions of sale.
Well, the part of this case that concerns me the most, and neither one of you had much time to discuss it, is the authentication question. And if there's any bigger significance, very significant to your parties, is the money involved. But if there's any bigger significance to what we write on this, is how you authenticate information like this. It does seem to me a better way to have authenticated would have been to go to proxy bid and have proxy bid say this is what it looked like and whatever else on the particular date. And that wasn't done. And or to have a well, anyway. So this was an indirect way, it seems to me, to authenticate Exhibit 41 by having a Henderson witness who was not personally familiar with it. Would you accept that there are more direct ways to have presented evidence of the authenticity of this document?
Perhaps, Your Honor.
No, perhaps. Isn't there?
We can all engage in Monday morning quarterbacking.
Well, that's the appellate court's business.
Yes. And it's not lost on me either. Would there have been a better way to skin the cat, so to speak? And perhaps so. But again, what we understood was that there was going to be a Henderson witness, Mr. McCon, who would testify as to what was in there. And then he retracted his affidavit after speaking with Mr. Koch ex parte. And we didn't get into that at trial, but there was never a disclaimer of the terms and conditions. He didn't say these weren't the ones. In fact, he was helpful in that he explained that these were the terms and conditions. So if you look at the totality of this, Your Honor, circumstantially and directly, the only way that we would know there's a 60-day requirement would be looking at the website and linking through to the proxy bid website and Henderson's terms on that. And then we have the disassembly. That's only published on the Henderson website. So again, I think the appellant was trying to take advantage of no disassembly and can't move it within 60 days. So they're trying to take advantage, and that was the crux of their case. You didn't pay for it because you didn't move it. The judge rejected Davie's defenses on that. But it was an integral part of the case. And so where did those terms come from, if not from the published terms and conditions? So it's circumstantially and really directly, Ms. Martin says she's got no reason to believe, based on her knowledge and experience as the auction manager, that these terms and conditions that were linked wouldn't have been the ones that applied to that auction.
All right, Counsel.
Thank you, Your Honor.
Your Honor, very briefly, I would analogize the production by Ms. Martin of these alleged terms to taking the documents and wrapping them around a rock and throwing the rock through the window into the courthouse, because that's what her testimony consisted of. She had no information about, she did not maintain these records. She did not make, she made an effort to ask those who might have information within Henderson. They all responded to her that they had no records The only information that she was able to obtain, according to her testimony, was that she spoke to the marketing person who prepared the terms and conditions and was told, we don't have them in Henderson, we don't have them on our computer, we don't have them on our website. You have to go to ProxyBid's third-party website. This is 2 years after the event. You have to go on to ProxyBid's website. She is not an employee of ProxyBid. She knows nothing about how ProxyBid works. She knows nothing about what documents were sent to ProxyBid. And she knows nothing about really anything concerning the ProxyBid Henderson Weinhoffer transaction. The witnesses that he should have called are Jessica, the marketing person who allegedly put together these terms and conditions that were on the ProxyBid website. He didn't call her. He should have called someone from ProxyBid to testify that this is the website, these are the terms and conditions that we received from Henderson and that we stored on our website. And yes, these were the terms and conditions that applied to the May 16, 2018 auction and not the January 2019 auction of the same module in the same location. But those witnesses weren't called, and as a consequence, we had no ability to cross-examine them. I mean, we all know that the basis of trustworthiness, the basis of attempting to ferret out whether something is true or not is the ability to cross-examine. And we had no ability to do that. We were put in the position of having to cross-examine that rock. You know, I've heard some statements from Mr. White about, you know, well, this all was because they only had 60 days to do it. If you look at Exhibit 6, which are the terms and conditions, it says you have to move it, bind it as is, where is. If you have any questions, call Jeff McCann, and it gives Jeff McCann's phone number. Mr. Davie, in his trial testimony, testified that he got online, he saw the advertisement for the module, and he called Jeff McCann. Jeff McCann is where he got where he was told that there was 60 days to make this leap of faith that he was only able to obtain that information through the website. There's no basis for that. There's no evidentiary basis for that. Mr. McCann was very clear. He did not know about this liquidated damage provision. Mr. McCann testified that it wasn't until this litigation that he, like Mr. Weinhoffer, discovered that this apparent liquidated damage provision was there. It was Mr. White that produced this liquidated damage provision for the first time. It wasn't Mr. Davie. When Mr. Davie was asked, well, when did you see this? Where did you see these terms and conditions? Who gave it to you? Well, I think it came from my lawyer. Now,
Counsel, your time is up. You do have your...
Thank you all very much.
Thank you. Thank you both. An interesting case.